This webinar will be broken down into the following areas. I will look at terminology first, and the terminology that is used in the cases where transgender issues arise. Then I will move on to explore the historical background to LGBTQ+ issues in the family court. Following on from this, I will address the main part of this webinar, focusing on the key areas where transgender issues arise in the family court. These areas are largely broken down into three core areas. The first is transgender parents in the family court, and that involves both public and private law cases. The second one is transgender young people in public law proceedings. And the third one is transgender young people in private law proceedings. And perhaps unsurprisingly, there is often some overlap between the cases that concern transgender young people in private and public law proceedings. In one part of the judgment, their lordships observed, in some respects, society has changed its views as to homosexuality so that it no longer interferes with what adults do between themselves or considers that it should be a criminal offence if indulged in privately between consenting adults. But it remains unnatural and society continues to disapprove of it. It is most dangerous for a young person to come into contact with it. The appeal was heard by the Lord Chief Justice, Lord Burnett, Lady Justice King, and Lord Justice Singh. The court observed as follows. In the present context, where we are concerned for the legislative measure, not a decision on the facts of a particular case, what Article 3.1 of the CRC, the Convention on the Rights of the Child, requires is that the best interests of children generally should be taken into account as a primary consideration when striking a balance in legislation. In our judgment, that is precisely what Parliament has done in enacting a carefully crafted set of provisions which balance the rights of transgender people and others, including their children.